Hi, very good morning. This is another interesting Supreme Court judgment. There are many interesting judgments, but I share a few of them actually. The citation is Kaveri Plastics versus Megdum Baba Bagruddin Nurul. This is under the Negotiable Instruments Act. Issue is issue was if the amount mentioned and demanded in the legal notice issued under section 138 of the Negotiable Instruments Act is different from the amount for which the check was issued. It could be even a typographical error. Whether the notice is valid in law or not. That are the issue before the Supreme Court. Facts: a complaint was filed by KP, that is Kaveri Plastics, against Nafto Gas India Private Limited. That was the company which issued the check. KP entered into MOU with that private limited company for a sale of land. Check was issued for rupees 1 crore by Megdum Bawa. He must be the person who signed the check on behalf of the company, the private limited company. When deposited into the bank, this check was returned with the note insufficient funds. So a demand notice, a legal notice was issued under section 138B. Unfortunately, at the final portion, when they demanded the amount, it was mentioned as rupees 2 crores instead of the check amount of rupees 1 crore. Then this Megdum Baba, he filed an application before the magistrate court saying that the legal notice is not as per section 138B and hence the complaint itself is not maintainable. The reply was filed by KP, Kaveri Plastics, which stated that it was due to an inadvertent mistake. Instead of mentioning 1 crore, we mentioned 2 crores. The plea of discharge was dismissed by the magistrate court. Magistrate court accepted the complaint. It said no, it is only an inadvertent mistake. Then a writ petition was filed before the High Court. High Court allowed the petition and held that the complaint was not maintainable. Appeal was filed before the Supreme Court against the order of the High Court. Supreme Court perused section 138B and noted the ingredients of section 138. Supreme Court said the words in section 138B within quote make a demand for payment of the said amount of money. I repeat, makes a demand for the payment of the said amount of money. That is there in the section 138B. In particular, the words the said amount of money, that holds the key to decide the issue. Supreme Court noted the various earlier judgments of the Supreme Court at various high courts. The principle that emerged from those judgments was that the demand notice must be the same amount of the check which was dishonored. The said amount must be the same amount of the check which is dishonored. That is the words said amount means it must be the same amount as mentioned in the check. That was the principle. Supreme Court held the words said amount and the phrase any amount of money have the same purport. They signify the check amount. They operate hand in hand for the purpose of applicability of the section. The nexus or linkage between the two is enacted by the legislature with the purpose of making the two to be the same and inseparable components. The former describing the offense and the later denoting the condition to be fulfilled for constituting the offense. Supreme Court said the notice is one of the main ingredients of the offense under section 138, legal notice. In the event of the main ingredient is not satisfied on account of discrepancy in the check amount and the amount mentioned in the notice. So check amount is different, the amount mentioned in the notice is different. Then all proceedings under section 138 would fall flat as bad in law. The notice must mention the same amount for which the check was issued. It must be exactly the same amount. After mentioning the exact check amount, sender of notice can claim legal charges, notice charges, interest, etc., etc. Whatever you want to claim, you claim. But your demand must be for the same check amount. When the check amount is not mentioned or the amount demanded in the notice is different from the amount for which the check was issued, notice is invalid in the IF law. Even if the check details are correctly mentioned, you mention all the details, date is correct, bank is correct, check number is correct, IFSC code is correct, everything is correct. But the corresponding check amount is not correctly mentioned, notice is invalid in law. The condition of notice under section 138B is to be complied with meticulously. Even typographical errors, this is very important. Even typographical errors can be no defense. The error, even if typographical, would be fatal to the legality of the notice. It needs strict mandatory compliance. Supreme Court held that in order to make a valid notice, it is mandatory that the said amount mentioned in the notice is the very same check amount and none other. Supreme Court approved the order of the High Court, which held that the complaint is not maintainable. My comments, as usual, these mistakes have become very common because of cut and paste technology available with the Word document. Normally, you cut this para and then even while dictating judgments, you can see judges saying, take from para 47 to 58 and then cut and paste it there in my judgment. Suppose if the judgment differs, the stenographer takes other judgment and cuts and pastes it, it will go totally wrong. Similarly, I am not saying that. Similarly, in Word document, cut and paste is usual. So this mistake could have happened because of cut and paste. Sometimes I have seen in the court, the prayer clauses are the prayer also. Cut and paste prayers are there. So sometimes that also happens. So it will be hilarious if you watch the court proceedings. Then when advocates, second point I want to make is when advocates file a complaint, that too if you are in the same field and you are doing the same type of work, how you become an expert? How you call a doctor as an expert doctor? Every time he is saying the same dolo, he is prescribing the same dolo 650. So the doctor can be named as dolo 650 doctor. Similarly, if you are an expert in some field, again and again 138 notice, 138 notice, 138 notice, the client, he will not even think about others. If there is a check bouncing, immediately he will go to ex judge, advocate. So because he is an expert, he knows everything. So again and again reading the same thing, he becomes bored. So the expert advocate will see the main contents only, main contentions, and then he will call his junior or the clerk and say, okay, you finalize this. This point you include, you file. So the mistake could have happened from the junior advocate or by the clerk. That is the point which I want to make. The third one is, I am not sure about this, but sometimes I have seen in my own draftings, it is not in 138, but in other draftings, when I read it, especially the numbers, suppose if it is 123, 456, some number you say, and typographically if it is typed as 132, 456 instead of 123, 456, mind reads it as 123, 456 only. The mind commits this mistake because when the client points out, sir, this number is wrongly typed, this amount of taxes which is mentioned there is not right, or the year is not right, something like that, when he points out, then you correct it. So my only thing is, I generally send a draft to the client first, gets his approval completely. I will say you check everything and then give your approval for this notice or the petition to be filed. After the client thoroughly checks, even though it is my responsibility, There is a I want what I want to say is there is a corresponding responsibility on the client, because who lost the case? Finally, it is the client who lost the case, uh, not the advocate. Even though partly I can say there is a mistake on the advocate, client also needs to be very very careful while issuing notices or filing petitions before the court. That is my simple suggestion. So I'm not criticizing neither the advocate nor the client. But this has happened. It's a costly mistake. Mistake. Even though if time is not barred, he may go before the civil court for claiming the amount. That is my comment. Thank you very much. Have a great and wonderful day.